When we're dealing with traffic stops, a seizure of the driver must end when the tasks tied to the traffic infraction are or should have been completed. Of course, we know this from Rodriguez versus United States, a 2015 Supreme Court case. So the question is, was the officer diligently pursuing issuing the citation, or was she asking unrelated questions to the traffic stop? If the officer chooses to prolong the stop, they must articulate reasonable suspicion that criminal activity is afoot beyond the initial traffic citation. I've discussed Rodriguez versus United States on this channel. I've also discussed many cases that followed it. My plan this week and in the weeks following to discuss some of the recent victories dealing with Rodriguez. And today we're going to look at the case where the officer pulls somebody over for speeding, but then chooses to call the K-9 unit, thus prolonging the stop because everybody has to wait for this K-9 unit to arrive, and all because the individual inside the car, the driver, had criminal history, and there were a bunch of air fresheners hanging off the gear selector in the vehicle. Is that legal? Is that a violation of the Fourth Amendment? Well, we'll find out in a few minutes. Before we go on, I want to thank you for watching me here on YouTube. Welcome to Lost Hash channel. If you're new, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to losthash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and other items. Thanks for watching.
Quick message from Lost Ash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lost Ash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lost Ash YouTube page. That's LAWSTACHE.
Today we'll be discussing United States versus Taylor, a case that was decided just this month in the 6th Circuit. But first, let me give you some factual background. Officer Cox pulled over Mr. Taylor for speeding. He was going 69 miles an hour in a 55 mile per hour zone. So far, pretty straightforward. She approached the vehicle and asked Mr. Taylor for the usual: driver's license, proof of insurance, and registration. He provided all of those things except for proof of insurance. He also volunteered some information. He said that he was traveling from a nearby restaurant where he just had a job interview. At this point, the officer told Mr. Taylor that she would go back to her vehicle to begin issuing a citation, but instructed him to look around his own vehicle to try to find proof of insurance, because if he can find it, she doesn't have to issue a ticket for that, only for speeding. She then went back to her car. Mr. Taylor began looking around his vehicle, and at some point, he put his hand out of the window with the documents, trying to get attention of the officer to tell her that he found the proof of insurance. At this point, the officer also looked in her own computer and found that Mr. Taylor had some criminal history. She then approached the vehicle again, got the proof of insurance, but told Mr. Taylor to stop moving around because he was making her nervous, which is pretty ridiculous considering that it was her that told Mr. Taylor to move around the vehicle to try to find proof of insurance. From that point on, Mr. Taylor did not move in the vehicle at all. The officer went back to her patrol vehicle, issued the ticket, but then she called a K-9 unit, thus prolonging the stop. When she called the K-9 unit, she said that she wanted them to arrive because Mr. Taylor had criminal history. He had a bunch of air fresheners hanging off the gear selector in his vehicle, and his travel plans did not make sense, meaning the information he provided about leaving a job interview. When the additional officers with the K-9 unit arrived, they put the dog around the vehicle. It alerted to narcotics. They searched the vehicle, but they did not find any narcotics. Instead, they found a firearm. which was problematic for Mr. Taylor because he's a felon. And so he was charged in federal court with being felon in possession of a firearm. But he filed a motion to suppress, saying that this was in violation of his Fourth Amendment because the initial officer, Officer Cox, once she issued the ticket, she had no authority to prolong the stop. Now, the government says that there was additional reasonable suspicion that justified prolonging the stop because the officer believed there was criminal activity afoot. Before we go on, let's talk about the law. Let's discuss the Fourth Amendment, which protects the right of the people to be secure in their persons against unreasonable searches and seizures. A traffic stop constitutes a seizure under the Fourth Amendment. The reasonableness of a traffic stop depends on whether the police had reasonable suspicion to believe that a traffic violation has occurred. A traffic stop that is constitutionally in bounds at its inception could eventually impinge on the vehicle's occupant's rights in some circumstances. If an officer executes a traffic stop unreasonably, the stop could violate the Fourth Amendment of the person seized. A lawful traffic stop must therefore be limited in scope and duration. An officer needs reasonable suspicion to prolong a traffic stop beyond what is necessary to resolve the initial reason for the stop. This is, of course, from United States v. Rodriguez, a 2015 Supreme Court case. Now that we understand the law, let's apply it. First, we know that the officer had reasonable suspicion to initiate the traffic stop because Mr. Taylor was speeding and thus violating a traffic ordinance. There's no question here. This is pretty straightforward, and everybody agrees on it. But the question is, could the officer then sit on the citation and wait for the K-9 unit to arrive? We know from Rodriguez that officers cannot prolong a traffic stop beyond what's necessary to issue a citation unless they develop reasonable suspicion that criminal activity is afoot beyond the initial citation. And here the government says that Officer Cox developed reasonable suspicion that additional criminal activity was afoot based on 4 reasons. Number 1, she did not believe that Mr. Taylor took a direct route from the restaurant where he just had the job interview to his house. Now, she knew where this restaurant was, and she knew where Mr. Taylor lived based on the driver's license. But here's the problem. She never asked Mr. Taylor where he was going. So even though this might not be a direct route from the restaurant to his house, we don't know whether he was actually going to his house. And so the court says this cannot be used as a factor in reasonable suspicion. Next, the government says that Mr. Taylor had criminal history. Now, courts have held that officers can use criminal history as reasonable suspicion that criminal activity is afoot, but only as a slight factor, usually in addition to other factors. So the court says we will give very little weight to this factor. Now on to the third factor, the fact that Mr. Taylor had a bunch of air fresheners attached to the gear selector in his vehicle. Courts have previously held that when individuals use air fresheners to mask odors of marijuana or some other narcotics, that can be used as reasonable suspicion that narcotics will be found inside the vehicle. But again, we have a problem here. Officer Cox never testified and never told anybody that she smelled the odor of narcotics or the scent from the air fresheners. Instead, she testified that she never smelled anything. So even though this can sometimes be used as a factor if there is a smell, here it was a fact that Mr. Taylor simply had a bunch of air fresheners. And without the smell, he wasn't using them to mask any odors. And finally, onto the fourth factor, the fact that Mr. Taylor was making a bunch of movements inside the vehicle. Now, this one is also problematic. When Officer Cox initially came up to the vehicle, Mr. Taylor was acting reasonably. He wasn't moving around. he only began to move around the vehicle after the officer instructed him to look for proof of insurance. Once she told him that he was making her nervous and to stop fidgeting around, he stopped moving around from that point on. So the court says this cannot be used against him as reasonable suspicion that he's doing something illegal or something suspicious. And additionally, Officer Cox never told anybody about this movement. When she called the K-9 unit, she only talked about the route to the house, criminal history, and air fresheners. She never mentioned the fact about the movement. The court says that if we look at all of these four factors, we're really only left with the fact that Mr. Taylor had criminal history. That is the only factor that gave any suspicion. But that alone is not reasonable suspicion that criminal activity is afoot. We can't judge somebody based on their criminal history that they're going to have something illegal in their vehicle. The court says that ultimately there was no reasonable suspicion, and the officer violated Mr. Taylor's Fourth Amendment rights when she prolonged the stop and began waiting for the K-9 unit to arrive. I hope you enjoyed this video. I hope you've learned something about the Rodriguez doctrine and the Fourth Amendment. If you've noticed, when we previously discussed Rodriguez, we're usually talking about the temporal aspect, meaning how much time is passing between the citation that's being issued and the time it takes for the K-9 unit to arrive. How long was the stop prolonged? That is usually the question. But here it was slightly different. Nobody was focusing on how long it took the K-9 unit to arrive, because clearly it probably took longer than it took Officer Cox to issue a citation. All parties agree that she was sitting on the citation waiting for the K-9 unit to arrive. So instead of focusing on the time frame, the court and the parties only focused on reasonable suspicion. And without additional reasonable suspicion that criminal activity is afoot beyond the initial citation, the officer cannot prolong the stop. Which means that all the items found in the vehicle, and in this case the firearm, must be suppressed and cannot be used against Mr. Taylor in court. I hope you enjoyed this video. If you're new to this channel, hit the subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to lawstash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and other items. Thanks for watching, and I will see you next Wednesday for another deep dive on another criminal case. Thanks for watching.